Thank you, everyone, and good afternoon. Thank you for joining us for our fourth and final Industrial Relations webinar held in partnership with AI Group for this round of webinars. We are once again joined by Brooke West, Senior Associate from AI Group Workplace Lawyers. Hi, Brooke. This webinar will cover the remaining amendments and recent case law developments and will include family and domestic violence leave changes, new model annual leave shutdown, federal court decision on the requirement to request that employees work on public holidays, introduction to the Fair Work Amendment Protecting Workers' Entitlement Bill, and the next tranche of IR legislation expected to be introduced in the second half of this year. For those that missed the previous three webinars, the recorded webinars and all the fact sheets are available on the AUSVEG website. We will also be sending a survey out after this webinar to all the participants. We'd like to hear your thoughts on the webinars and what topics you'd like us to cover in the future. Thank you for everyone attending these webinars, and I'll pass you over to Brooke. Thank you, Brooke.
Thanks, Lucy, and welcome to all growers joining us for briefing number 4. As per Lucy's introduction, we'll be covering off a few things today. So firstly, the remaining areas of workplace relations in which we have some recent changes, specifically the paid family and domestic violence leave. I'll also be covering off on the record keeping and payslip requirements that were recently introduced into the Fair Work regulations. I'll then be covering off on some recent developments, particularly in the Fair Work Commission, and then some case law which would be relevant to growers in respect of shutdown and in relation to managing your workforce as it relates to work on public holidays. Then I'll be covering off on the government's implementation of its Tranche 2 amendments, which have been recently introduced by the Fair Work Amendment Protecting Workers' Entitlement Bill. So I'll go over the aspects of the bill that are relevant to growers and which you should be aware. But I will say, but for the most part, the amendments are what's said to be the less controversial amendments that we are expecting from the government as part of their election commitments. And we can consider that these should have a limited impact on growers generally, but they're nonetheless important to be aware of. And then finally, I'll be finishing off briefly discussing the third tranche of legislative amendments currently being considered by the government and the areas that we are expected to see further legislative change later on in the year. I will cover off on those areas which are expected to be most relevant to industry. So starting off with paid family and domestic violence leave. So by way of background, the Fair Work Amendment Paid Family and Domestic Violence Leave Bill 2022, or I'll refer it to as the Amending Act, passed through Parliament on the 27th of October 2022. And in summary, the Amendment Act varies the National Employment Standards, or the NES, in the Fair Work Act to give all employees, including casual employees, up to 10 days of paid family and domestic violence leave each year. This replaces the entitlement in the NES previously, which provided 5 days of unpaid family and domestic violence leave. The definition of family and domestic violence leave has also been extended to include conduct of a current or former intimate partner of an employee or of a member of their household. And the entitlement is effective from the 1st of February 2023 this year, although if you are a small business employer or grower, you will have until the 1st of August 2023, so this year, to provide the new paid entitlement to eligible employees. So all types of employees are able to potentially access paid family and domestic violence leave. So this includes casual employees as well as full-time and part-time employees. An employee, again, is entitled up to 10 days of paid family domestic violence leave each year. And the entitlement does not accumulate from year to year like other forms of paid leave. However, unlike most other types of leave under the National Employment Standards, this type of leave is not calculated on a pro rata basis relative to an employee's ordinary hours of work. So an employee may take paid family and domestic violence leave if the employee is experiencing family and domestic violence and the employee needs to do something to deal with the impact of the family and domestic violence, and it is impractical for the employee to do that thing outside the employee's work hours. So a note in the National Employment Standards usefully identifies the following examples of activities for which an employee may be able to access paid family and domestic violence leave. And those examples include attending counselling or appointments with medical, financial or legal professionals, arranging for the safety of the employee or a close relative, which includes relocation, and attending attending court hearings or accessing police services. So the new entitlement permits employees to take paid family and domestic violence leave when they need to do something to deal with family and domestic violence during their work hours. So this represents a change to the previous unpaid National Employment Standard entitlement, which only arose when an employee needed to leave to attend to a relevant matter during their ordinary hours of work. So a consequence of the variation to the NES is that an employee may be able to access the leave during overtime hours and receive payment calculated by reference to those hours. And that's something that I will get to in a moment. Again, the definition of family and domestic violence has also been extended in the Fair Work Act to include conduct of a current or former intimate partner of an employee and a member of an employee's household. And family and domestic violence violence is now defined in the Fair Work Act as violent, threatening, or other abusive behaviour by a close relative of an employee, a member of an employee's household, or a current or former intimate partner of an employee that A, seeks to coerce or control the employee, and B, causes the employee harm or to be fearful. The definition of close relative in the Fair Work Act, however, has not changed, and that is defined in the Act as a person who A, is a member of the employee's immediate family, or B, is related to the employee according to Aboriginal or Torres Strait Islander kinship rules. So moving to the rate of pay that an employee is entitled to when they take a period of family and domestic violence leave. So the manner in which payment for the entitlement is to be calculated does differ slightly between permanent and casual employees. So for an employee other than a casual employee, so part-time and full-time, payment must be at the employee's full rate of pay, worked out as if the employee had not taken the period of leave. And for a casual employee, payment must be at the employee's full rate of pay, worked out as if the employee had worked the hours in the period for which the employee was rostered. So this will include circumstances where a casual employee has accepted an offer by the employer or you as a grower to work certain hours. So the explanatory memorandum to the Amendment Act provides that a casual employee, for a casual employee, this would include situations where the employer makes available to the casual employee by any means a list of shifts to be undertaken by the casual employee in advance, and an offer and acceptance of work that had been agreed orally. So there's no need for it to be confirmed in writing. The Amending Act provides that a casual employee may take a period of paid family and domestic violence leave that does not include hours for which the employee is rostered to work. However, in that circumstance, you as a grower would not be required to pay the employee for the unrostered hours. So this basically ensures that a casual employee who is not able to make themselves available for a shift that they have been asked to perform, even though it has not been rostered, they cannot be adversely treated because they need to do instead something to deal with family and domestic violence leave during that period. So it's just an added protection for casual employees. So again, payment for family and domestic violence leave must be at the employee's full rate of pay. The full rate of pay is different to the base rate of pay, which applies when an employee accesses most forms of paid leave under the NES. And on the slide there, I provided an example of Section 99 of the Fair Work Act, which relates to payment for personal and carers leave. And you can see there the reference underlined that the employer must pay the employee at the employee's base rate of pay. So an employee's full rate of pay is defined in the Fair Work Act as the rate that is payable to an employee, and this includes incentive-based payments and bonuses, loadings, monetary allowances, overtime or penalty rates, and then other separately identified amounts. So the identification of what is required to calculate an employee's full rate of pay may be difficult for growers in some circumstances. We acknowledge that, particularly where amounts that may be earned had the employee worked are not readily identifiable. The explanatory memorandum to the amending act does provide some guidance on the calculation of the payment for the form of leave. And it says the intention is that employees taking paid family and domestic violence leave will receive the same remuneration they would have received had they not taken the leave as far as possible. Employers would be required to pay employees in relation to a period of paid family and domestic violence leave amounts the employee would otherwise have earned, provided those amounts can be identified and calculated with a reasonable degree of certainty. So conversely, for irregular payments or amounts contingent upon certain events that may or may not have happened during the employee's rostered hours, an employer may not be liable to pay an employee those amounts. It does also provide a bit of an illustrative example of what that means. And that includes an employee would be entitled to be paid overtime rates where they were rostered in advance to work overtime on a day they take paid family and domestic violence leave. However, an employee may not be entitled to be paid travel allowance in relation to a period of paid family and domestic violence leave if the calculation of that allowance was based on the distance travelled and where the distance that would have been travelled during the period the employee took the leave cannot be ascertained. So that just gives you a bit of an example as to how that operates and when something would be readily identifiable or reasonably identifiable. In terms of notification, so an employee must give you, a grower, notice of taking the leave as soon as practicable, which may be at a time after the leave has started, and advise an employer or a grower of the period or expected period of the leave. An employer can ask their employee, so a grower can ask your employee for evidence that shows the employee took the leave to deal with the family and domestic violence. If the employee doesn't provide the requested evidence, they may not get paid the leave. And this is subject to a bit of sensitivity, noting the type and the nature of why an employee might want to take the leave. So it's totally up to you as a grower as to how you deal with this, whether you request evidence, whether you think it's justifiable in the circumstances. There is a clause in the Fair Work Act that says the evidence has to convince a reasonable person that the employee took the leave to deal with the impact of family and domestic violence, and it's not practical for them to do so outside their work hours. So just as an example, the types of evidence that you could request could include a statutory declaration, documents issued by the police service, issued by a court, or family violence support service documents. Again, whether it's reasonable to request such leave evidence of the leave will be a fact-by-fact, case-by-case rather basis. Up to you. Importantly, growers must take steps to ensure that if they do receive evidence or information concerning any notice or evidence that an employee has been given for the purposes of taking paid family and domestic violence leave, it must be treated confidentially and as far as reasonably practicable to do so. In addition, a grower must not, other than with the consent of the employee, use such information or evidence for a purpose other than satisfying it yourself in relation to the employee's entitlement to the leave. However, an exemption to that is that you're not provided from dealing with the information if doing so is required by an Australian law or is necessary to protect the life, health or safety of the employee or another person. So moving on to the record keeping requirements of paid family and domestic violence leave, this is really important and something that growers need to be aware of. So on the 8th of December last year, the Fair Work regulations introduced a number of requirements which prevent growers from disclosing certain information about an employee's paid family and domestic violence leave entitlement on a payslip. Growers are required under the initial payslip requirements to not disclose the following information on an employee's payslip. That includes a statement that an amount paid to an employee is a payment in respect of an employee's entitlement, and a statement that a period of leave taken by the employee has been taken as a period of paid family and domestic violence leave, and the balance of an employee's entitlement to be paid family and domestic violence leave. Now, the Fair Work regulations, as a part of this change, initially included a note in relation to the requirements set out in Regulation 3.47A on your screen there. And the one way in which an entitlement could be described on a payslip is special leave, miscellaneous leave, or leave other. However, in response to concerns that describing a payment as relating to the family and domestic violence leave could create difficulties or risks for an employee accessing that relevant entitlement. So on the 3rd of February this year, the government made further amendments to the Fair Work regulations in response to those concerns and risks. And under these amendments, the regulations deleted that note and introduced additional obligations relating to the content of payslips. So there's an additional requirement under the Regulation 3.48, and that requirement specified that an amount paid to an employee must not report on a payslip as an amount paid to the employee for taking a period of paid family and domestic violence leave, and must instead report an amount paid to the employee for taking a period of paid family and domestic violence leave as payment for the performance of an employee's ordinary hours of work, or as another kind of payment made in relation to the performance of an employee's work, which includes and is not limited to an allowance, bonus, or a payment of overtime. So the new requirements will typically mean that a payment made to an employee in respect of a period of paid family and domestic violence leave will need to be recorded on a payslip as though the employee had worked instead of accessing the entitlement. If an employee requests it, a grower may actually report a payment relating to family and domestic violence leave on a payslip as an amount for taking some other kind of leave. So, for example, an employee who has told an abusive partner, for example, that they have taken carers leave or annual leave, when in fact that employee has taken paid family and domestic violence leave, may request that you report that that relevant payment was made for carers leave or annual leave on their payslip. However, a grower is not required to comply with that request in circumstances where it may be difficult for you to accommodate it. So that's in recognition, particularly when requests are made at short notice, due to the nature of the limitations on payroll systems, etc. And finally, an important note here is that noting the requirements of the regulations, the Fair Work Act has also been amended to provide that a payslip is not false or misleading merely because it complies with the family and domestic violence leave reporting requirements set out in the Fair Work regulations. So moving on to the recent Fair Work Commission proceedings of interest and case law developments, and we'll start with the Fair Work Commission's 4-yearly review of modern awards. In their plain language proceedings, they addressed shutdown provisions in modern awards. And in a decision, which was issued on the 22nd of December 2022, go back one step. The Fair Work Commission found on its own volition that it did not have the power to include terms in a modern award that enables an employer to direct an employee to take unpaid leave. So on that basis, the Fair Work Commission decided to significantly vary the annual leave shutdown provisions in 78 modern awards by replacing them with a new model annual leave shutdown clause. Prior to this decision, many awards contained annual leave shutdown provisions which allowed an employer to direct an employee to take a period of unpaid leave if that employee did not have a sufficient annual leave balance to cover the entire shutdown period. So this ability to direct an employee to take unpaid leave has now in effect been removed. Importantly, though, whilst the ability to direct an employee onto unpaid leave during a shutdown period has been removed, what the model clause or the new clause does allow is an employer and an employee to agree to a period of unpaid leave as a part of a shutdown period. I acknowledge and advise that the horticulture award does not actually include a shutdown clause, and therefore it was not subject to this decision or variation. But growers may employ workers in a variety of roles and capacities, and for whom another award may apply, including the Clerk's Award as just one example. So in summary, the model clause will not include an express right for an employer to direct employees to take unpaid leave in circumstances where they don't have enough annual leave accrued to cover that shutdown period. It will not remove any existing limitations on when a shutdown period may be imposed. So for a variety of reasons, employers and growers may have periods of shutdown, whether it be for, maintenance of machinery, etc. There's no limitation on when that can occur. That has been maintained within the award system. Thirdly, it will require growers to provide at least 28 days written notice of a shutdown, unless the award already prescribes a longer period of notice, and in that case, the longer period will be retained. And in those circumstances, if an affected employee is engaged after the notice has already been given, they must be provided with written notice as soon as practicable after they are engaged. And importantly, that 28-day period can be shortened if you agree, if it's agreed with the majority of your relevant employees. And lastly, the model clause will require that any direction from an employer or you as a grower to take annual leave during a shutdown must be reasonable. So a practical implication of the decision is that where employees do not have sufficient annual leave to cover the shutdown period, growers may either need to firstly secure agreement from the employee or employees to take a period of unpaid leave, pay employees for the shutdown period, even if the employees perform no work, or allow employees to work. However, that being said, growers can mitigate the impact of this model clause through a variety of methods. Firstly, managing annual leave approvals to ensure that existing employees maintain enough leave to cover a shutdown period or a future shutdown period. Section 88, of the Fair Work Act does allow an employer to refuse an employee's request for annual leave if the refusal is reasonable. And so in the decision, the Fair Work Commission did express a view that an employer's refusal of a request for annual leave may in fact be reasonable if it would result in an employee having insufficient leave to cover a proposed shutdown. Secondly, the employee may agree to use other forms of paid absence to cover that period. For example, a shortfall in accrued annual leave might be managed by an agreement to access accrued time off in lieu of overtime, accrued rostered days off, or annual leave in advance, as an example. It is important to note that in the awards and other industrial instruments, it's often the case that still requires agreement from the employee to take other forms of leave. So just be mindful of that. A grower may also be able to direct an employee to perform alternative duties during that period to those which they would ordinarily perform. And that would depend on the individual circumstances of the employee, but it is an option available. At the other end of the scale, we have a grower can make an enterprise agreement with its employees that provide terms with dealing with shutdowns that do differ from the relevant modern awards. Or alternatively, if you already have an existing enterprise agreement, you could seek to have that varied to ensure that it contains shutdown provisions that meet the requirements of your specific operations. And then finally, growers could also consider the requirement to pay an employee for that period could be subject to the terms of the employee's contract of employment. And you may wish to consider including terms in employment contracts and any new employment contracts that deal specifically with the shutdown period and payment of that shutdown period. So now we are moving on to another recent decision, which has interestingly attracted a degree of attention over the past few weeks. And that is the case of the Construction of Forestry, Maritime Mining and Energy Union, or the CFMMEU, and OS MCAP Pty Ltd 2023. And this was a case in the full bench of the Federal Court. And in this case, the recent judgment, the full bench has dealt with the provisions of the National Employment Standards under Section 114 of the Fair Work Act, which affords employees a right to be absent on public holidays and the capacity of employers to seek that they undertake work on such days. Importantly, the decision indicates in effect that an employee who is requested to work on a public holiday may refuse the request if it is not reasonable, or the employee has the reasonable basis for refusing to work. If the employee does not have a proper basis for refusing the request, then the employee may ultimately be required to work on the public holiday. And in this case, the full court also clarified what a request must constitute under Section 114 of the Fair Work Act. So, background and summary of the facts in this case, OS MCAP employs production employees to operate mobile machinery, which includes shovels, excavators, loaders and trucks for its mining clients, including a number of BHP operations in Australia at the Darnia mine in Queensland. OS MCAP employees were engaged on a standard form contract which contained a provision that foreshadowed they may be required to work on public holidays, and that payment for such work was included in their remuneration. So on commencement, each employee was provided with a roster on a laminated card when they first commenced, which identified all of the shifts that they were expected to work, and also whether they were 7 days on, 7 days off, and this included public holidays that they would be required to work. Now, in August 2019, OS MCAP became aware of a number of employees putting applications for annual leave, mainly for Christmas Day and on Boxing Day. OS MCAP's arrangements at the mine allowed for a maximum of 7 employees per roster panel to be absent on planned leave at any one time, and that would be exceeded if all of the requests for annual leave were granted. So, in response, OS MCAP undertook a process by which those employees who could be absent on Christmas Day and Boxing Day would be drawn at random, with all remaining employees required to work on the public holidays. As a result of that process, approximately 85 employees worked a 12.5-hour shift on the Christmas Day and the Boxing Day public holidays. So OS MCAP do not at any time from the commencement of employment communicate with employees that they had a right or otherwise to refuse work on Christmas Day or public holidays generally. So the CFMMEU contended that by imposing a requirement that the relevant employees work on a public holiday in accordance with the roster that it had issued, OS MCAP had contravened Section 114 of the National Employment Standards. So Section 114 of the Fair Work Act provides that an employee is entitled to be absent on public holidays. However, an employer can request an employee to work. An employee's right to refuse the request is limited to circumstances where, firstly, the employer's request is not reasonable, or secondly, the employee's refusal is reasonable. So because of Section 114, OS MCAP asserted that a request to work on a public holiday included a requirement to do so. However, the union contended that request was not in any shape, way or form synonymous with require, and that this approach still contravenes Section 114 of the Fair Work Act. So at first instance, a single judge of the Federal Court did in fact find in favour of OS MCAP, and it found that the employer's approach had not breached the Fair Work Act. However, this decision was appealed by the CFMMEU, which takes us to the decision of the full bench of the Federal Court. So what did the full Federal Court find? They upheld the appeal, and they found that the judge at first instance had in fact erred in his consideration on the matter. And in doing so, the full court found that the employer, so OS MCAP, had required the employees concerned to work on the relevant public holidays, and it had not engaged in discussion or negotiation around the direction such that it could not be said that the employees had been requested to work on the public holidays as contemplated by Section 114 of the Fair Work Act. So according to the full court, there must be a request, thereby leaving an employee with a choice or room for negotiation and discussion as to whether they work on a public holiday, and that also includes the capacity to refuse. So importantly, the full court found that Section 114 affords an employee a right to be absent on a public holiday, but that Section 114 also permits an employer to request that an employee work on the public holiday, and then only permits such a request to be refused if either the request is not reasonable or if the refusal itself is reasonable. So in deciding whether a request or a refusal is reasonable or unreasonable, the various factors in Section 114, subsection 4, must be considered. So this includes, for example, and there is a list, that amongst other things, the nature of the employer's workplace and the nature of the work performed by the employee, and the employee's personal circumstances, including family responsibilities. So the significance of the decision is the emphasis placed by the full court on the need for an employer to request, rather than simply require that an employee work on a public holiday. So in light of this decision, can a grower ever require an employee work on a public holiday? Look, the answer to that is yes. But the decision does, however, highlight that a grower's capacity to require an employee to work on a public holiday will again depend on the specific circumstances, and the grower first following a process that involves them requesting or asking the employee to work. So the full court held that a grower can ultimately require an employee to work on a public holiday, but importantly, once the request under Section 114 is made, the employee's right or refusal is limited to two scenarios. Again, the request is unreasonable or the employee's refusal is reasonable. So, provided that a grower requests the employee to work on a public holiday, the request is reasonable, and the employee has no reasonable basis to refuse the request, then a grower may require the employee to work on a public holiday in accordance with that request. Now, the full court did acknowledge that operational requirements, contractual obligations, and the nature of the enterprise were all factors relevant to the consideration of whether a request to work on a public holiday was reasonable. And it also acknowledged that this process may be administratively burdensome, but did note that Section 114 was structured in such a way as to avoid employee entitlements being abrogated for convenience. So what potential practical options are available to growers? Again, the court's decision indicates that a grower must not simply roster employees to work on a public holiday. Instead, they should ensure that, that it is clear that any such roster constitutes or is accompanied by a request that employees work on a public holiday. So accordingly, where a grower intends to operate on a public holiday and it wants employees available to work, a provision can be included in their contracts which specify that they may be requested to work on public holidays, and they may in some circumstances be required to work on those public holidays where the request is reasonable and their refusal to work is unreasonable. It's important to note, however, this will not negate the need to actually request that they work on public holidays. Secondly, where a grower is preparing a roster for a period that includes a public holiday, you could specify that the draft roster provided constitutes a request to work on a public holiday, and that employees should advise if they cannot work on that relevant day in question. Or alternatively, a grower could issue a request to employees to work on a public holiday separate to any roster. So we now move on to the most recent legislative changes introduced by the government as part of its planned legislative reforms. So on the 29th of March this year, the Fair Work Legislation Amendment Protecting Worker Entitlements Bill 2023 was introduced into Parliament. It's still subject to debate and hasn't passed through Parliament just yet. But the bill gives effect to what is commonly being referred to as the second tranche of the government's industrial and workplace relation changes planned by the government. As touched upon before, these changes are considered to be the less controversial amendments, and the more controversial parts of the government's commitments will be dealt with in legislation in the second half of this year in tranche 3, and I will come to that next. So the Protecting Worker Entitlements Bill proposes changes to unpaid parental leave, introduces a right to superannuation within the National Employment Standards, changes to payroll deductions for authorised purposes, including for union fees, providing casual workers in the black coal mining industry with access to long service leave entitlements, clarification that the Fair Work Act applies to migrant workers, and lastly, clarification that when a workplace determination takes effect. So I will not be discussing the changes in respect of casual employees' long service leave entitlements in the black coal mining industry, or the clarification in relation to workplace determinations, given that they are unlikely to be relevant to growers. So firstly, starting with the changes to unpaid parental leave, the Fair Work Act currently does allow for an employee to take 30 days as flexible unpaid parental leave, which can be taken at any time within the first 24 months of a child's birth or adoption placement. So flexible unpaid parental leave days are an exception to the requirement that unpaid parental leave must be taken in a single continuous period. So the proposed changes to the flexible unpaid parental leave is intended to align to the entitlement to the recent changes to the government's funded paid parental leave scheme. So in summary, the bill proposes to broaden access to unpaid parental leave by allowing parents to commence unpaid parental leave at any time in the 24 months following the birth or placement of their child. It increases the amount of flexible unpaid parental leave from 30 days to 100 days, or a higher amount of days if that's prescribed by the regulations. It gives pregnant employees the option to take flexible unpaid parental leave during the period commencing 6 weeks before their child's expected birth date. So any flexible unpaid parental leave access would be deducted from the employee's overall entitlement to flexible unpaid parental leave. And so this means a pregnant employee may, for example, work part-time hours by combining periods of work with periods of flexible unpaid parental leave before the birth of their child. In addition, it is proposed that employees will be allowed to take unpaid parental leave before and after a period of continuous unpaid parental leave. So currently, in order for an employee to access both continuous unpaid parental leave and flexible unpaid parental leave entitlements, the employee must take continuous unpaid parental leave first and then take flexible unpaid parental leave. So the proposed change would allow, for example, an employee to access a period of flexible unpaid parental leave before the birth of their child, then take a period of continuous unpaid parental leave, then access their remaining flexible unpaid parental leave entitlement. And finally, to promote shared caring responsibilities between parents, the bill also seeks to remove the concept of concurrent leave and now will allow employees to take unpaid parental leave at the same time without limitation. Moving now on to the changes to permitted deductions. Currently, there are various types of permitted deductions that may be made from an employee's pay, and that's contained in Section 324 of the Fair Work Act, where the deduction is authorised in writing by the employee and is principally for their benefit. And it's the same amount as specified in the authorisation. That authorisation currently can be withdrawn in writing by the employee at any time. So the proposed amendments are intended to clarify the circumstances in which employees can validly authorise deductions and to permit greater flexibility in relation to the deductions that can be authorised by an employee. So if the bill is passed in its current form, the additional rules would apply to those deductions. Firstly, for a single deduction, the employee's authorisation must specify the amount to be deducted. Secondly, for multiple or ongoing deductions, the employee's authorisation must specify whether the deductions are for a specified amount or for amounts as varied from time to time. Such deductions should not be for the direct or indirect benefit of the employer, and that's currently a requirement in the Fair Work Act, so that's not changing. And lastly, any variation in a specified amount of a deduction must be authorised by the employee in writing. So despite those changes, Again, the general rule is that a deduction cannot be made for an amount that may vary from time to time, where it is directly or indirectly for the benefit of the employer. So the only exception to that general rule is where the deduction is reasonable under the Fair Work regulations. And there are some examples that are included in the Fair Work regulations, and that includes a deduction where the purpose is to recover costs directly incurred by an employer as a result of the employee's voluntary private use of the employer's property that is authorised or unauthorised. So an example of that is the private use of a company vehicle, a mobile phone, or a corporate credit card. So these changes would apply in respect to written employee authorisation made 6 months or later after the bill commences operation. And this is to allow time for employers and employees to review their current arrangement and for employers to update payroll system as required. Interestingly, this particular amendment has been the subject of a bit of debate in the upper house. So it may or may not pass through Parliament as is proposed. So this particular item could be subject to change. Superannuation in national employment standards. So currently, the only way for an employee to pursue unpaid superannuation is through the Australian Taxation Office. And whilst some employees already have a legally enforceable right to superannuation contributions under the Modern Award or Enterprise Agreement, for example, the Horticulture Award has a clause about the requirement of an employer to make superannuation contributions. The bill does propose changes that will ensure all workers covered by the Fair Work Act will be able to take legal action by making an entitlement to superannuation contribution as one of the Australian National Employment Standards. Currently, it is not a NES standard. But it is important to note, and for growers to know, that this does not introduce additional superannuation obligations for growers. We know that that system is complex. It's rather just incorporating all of your existing obligations under the Superannuation Guarantee Administration Act. So that hasn't changed. Your obligations with respect to super, how you pay it, when you pay it, has not changed. It is proposed, basically, it's intended to replace the Australian Taxation Office existing powers. So it is not intended, sorry, to replace the ATO's powers to recover superannuation amounts either. So importantly, what this change means is, as a NES entitlement, a failure to make a compliant superannuation contribution would, if the bill is passed, be a contravention of a civil penalty provision of the Fair Work Act, which would expose growers and employers to penalties. That's presently not the case. So the change would allow employees and registered employee organisations, for example, unions, or the Fair Work Ombudsman, to bring court proceedings in order to recover allegedly unpaid superannuation contributions, with payment to the employee's superannuation fund to be the usual but not only form of compensation. But applicants would also be able to seek civil penalties for such alleged underpayments. The NES entitlement will only apply to superannuation guarantee charge percentage. So that's currently your 10.5%. That's about to be increased to 11% in the next financial year. But where employees have a separate entitlement to the superannuation contribution, which is calculated at a greater rate, they may enforce those entitlements through other and separate mechanisms. So this is only in relation to the minimum super guarantee charge. Again, specific provisions preventing multiple actions have been included, which is a bit of a safeguard, but where the ATO has commenced action in respect to an employer with superannuation shortfall, proceedings cannot be brought in respect to this new NES entitlement. Unfortunately, the bill does not contain protections for employers who may have relied upon an ATO ruling or other guidance material released by the ATO in determining whether superannuation payments would be payable in certain circumstances. So instead, the explanatory memorandum does note that it is anticipated that a court would have due regard to any relevant administrative guidelines or guidance produced by the ATO regarding the interpretation of superannuation obligations on which the employer has relied. Again, it is the intention of the NES just to give employees the ability to recover unpaid superannuation in a way that is complementary but additional to the ATO's role. Moving on to protections for migrant workers. The bill seeks to clarify that migrant workers, regardless of their immigration status, are entitled to the benefits of the Fair Work Act. So this includes entitlements under the NES and all other entitlements conferred by the Fair Work Act or a Fair Work instrument, so awards, enterprise agreements, etc. So what it means is that a breach by a migrant worker of the Migration Act would not affect the validity of a contract of employment or a contract for services for the purposes of the Fair Work Act. So this would include an individual not having work rights for the purposes of the Migration Act, breaching a condition of his or her visa, or not being entitled to remain in Australia in accordance with a visa. So in those circumstances, although there may be consequences due to the non-compliance of the Migration Act, the individual would still be entitled to the protections of the Fair Work Act when performing work. And finally, moving on to the more controversial parts of the government's commitments. The government is currently planning further reforms to the Fair Work Act, and they are expected to be implemented in the second half of the year. So the government is currently actively consulting with key stakeholders on the next proposed reforms. And the areas of key change we expect to see are on the slide there for you now. I won't be going through each of these. There are a lot there. However, the changes that are likely to impact and be of interest to growers the most, specifically in relation to casual employment, same job, same pay, so labour hire, and the criminalisation of wage theft. So in relation to casual employment, the key changes that we expect relate to legislating an objective test to determine when an employee can be classified as a casual, and this was a key government election commitment. The government is also seeking or looking at reversing the previous government's amendments to the Fair Work Act, where it clarified a person's employment status as a casual is set at the point of engagement, and the definition of casual employee explicitly excludes consideration of any subsequent conduct of the employee or the employer. So the government considers that this results in an employee being classified as a casual even though they work regular predictable hours, and basically they want to change that. Lastly, the changes in terms of the definition of casual employee may also have as a consequence a change to the current casual conversion framework presently in place. So we are expecting some significant change to casual employment, the definition, casual conversion. So this is definitely something that should be on your radar, and we do expect some significant change in this space. The government is also considering how to implement the same job, same pay measures. So those measures basically seek to address the limited circumstances, and they acknowledge that it is limited, in which host employers' use of labour hire to deliberately undercut the bargain wages and conditions set out in the enterprise agreements made with their employees. So in this space, the government is considering ensuring businesses are able to access labour hire for genuine work surges and short-term needs. So there is an acknowledgement there that there is a genuine need for the use of labour hire, and they don't want to remove that flexibility. But what they do want to ensure is that labour hire workers are paid at least the same as directly engaged employees doing the same work. This includes how should the same job be identified? How should same pay be calculated? What are the definitions? That's a very complicated and complex area, and they are looking at it actively. They're also looking at how labour hire arrangements should be identified or defined, broadening the Fair Work Commission's jurisdiction to deal with disputes for labour hire employees. So currently there's no recourse. They have no right or jurisdiction within the Fair Work Commission for disputes or to enforce anything. So they're looking at broadening the Fair Work Commission's remit. And they're also considering targeted anti-avoidance measures that are needed to protect the same job, same pay entitlements. So I understand that this is a significant area for the industry. Lucy has told me that AUSVEG is actively involved in these matters as they relate to same job, same pay measures, and they are advocating for growers to ensure their interests are considered and protected. And lastly, we know, unfortunately, wage underpayment continues to be a feature across a range of Australian workplaces, for small business to large corporations. But we also know that sometimes it's not intended. It happens by mistake. But in response, the government has made an election commitment to introduce a criminal offence for wage underpayment for the most serious forms of exploitative conduct and to increase penalties for contraventions in the Fair Work Act. So they're considering two active measures, one introducing a criminal offence and then looking at increasing penalties. So the measures to criminalise wage theft are proposed again to introduce criminal offences for wage underpayment and record-keeping misconduct. They are looking at existing civil compliance and enforcement frameworks under the Fair Work Act, and this includes the serious civil contraventions regime. And they're doing that to ensure that the framework contains what they're calling a sensibly graduated scale of penalties to address the full spectrum of non-compliance with workplace obligations. So I think that's an acknowledgement there that this happens. Sometimes it's deliberate, sometimes it's not. They're seeking to find a measure that strikes that balance appropriately. Again, they are increasing the maximum penalties for wage exploitation related civil remedy provisions in the Fair Work Act, and they want to strengthen protections against sham contracting arrangements. Importantly, the government has foreshadowed, though, that the proposed criminalised criminal penalties will not apply to growers who do make an honest mistake and they take steps to fix it. So this is an incentive. You know, as we know, a variety of employers do report to the Fair Work Ombudsman. They come forward and they acknowledge that they've made mistakes and that they're wanting to fix them. They're proactive, they're cooperative. The government does not want to de-incentivise that approach currently taken by employers who, for whatever reason, find errors, find mistakes, and they want to fix them. So, hoping to keep that momentum going, I suppose. So again, we expect that these measures will be introduced into a further bill later this year. And so it is important to note that the areas I have covered don't represent any government decisions on the final framework to be included in the bill, and this may be subject to change. So the full extent of the legislative changes and the precise nature of those changes will become clearer once a bill is introduced into Parliament. A further briefing for growers may follow once the bill is implemented, or that the change is introduced and passed through Parliament. So that concludes today's briefing, and it is the last in our series of planned sessions for now. As always, subsequent to today's session, I will be providing you with written material and fact sheets that will include all of the information that we have covered today for your reference. And once again, thank you for joining us today. It has been an absolute pleasure presenting to growers over the past few months. I hope to see you all again soon for future briefings as the next tranche of reforms progress. Thanks, Lucy.
Thank you, Brooke, and I'd like to take this opportunity to thank you and AI Group for presenting these webinars. I know from feedback that they've been exceptionally beneficial, and the fact sheets and the resources you've provided have also been well received. Thank everyone who's attended these sessions. We are discussing with AI Group what we might be doing going forward. And as I mentioned earlier, we'll be sending out a survey too. AUSVEG is obviously following closely the current and the future proposed changes. Thank you, Brooke, and thank you, everyone. And we'll see you at the next webinar to be decided.
Thanks.